Good morning, everybody. Thank you very much for joining us. We apologize for the slight delay. We are currently streaming live the press conference to our other platforms. I will indicate once we have gone through the press statement and we go into the question and answers when we will be stopping the streaming. I have with me today the dear Federal Chairperson, Helen Zille, who will be taking us through first on the content of the press conference, joined by also Werner Horn, who is our representative at the IEC. I will be chairing the press conference, and if you can what you can do when we're opening to questions, you can put your questions in the chat box, or you can send them directly to Bongisa or myself. I will then be able to allocate the questions to the various, either Helen or Werner. And also, if you can, when you are introduced, when you are on the platform, you can either speak or put it on the writing. And if you can just let us know who you are and from which media platform you are coming from. Helen, I'm going to hand over to you to take us through the press statement, and then you can hand over to Werner to perhaps expand on some of the technical details, and then we will close and open to questions.
Thank you very much indeed, Siviwe, and good day, everybody, and thanks for coming to our press conference. We greatly appreciate it. We do believe that it is a very, very important one. In order to start taking you through the DA's position, I'm going to share my screen with you, and I'm going to take you through the press statement that we will be issuing right now in order to explain our submission in joining the IEC's matter to the Constitutional Court, in which the IEC is seeking a postponement of the election scheduled for the 27th of October. Now, we are joining that application because we are obviously an interested and affected party, and we are joining the application to strongly oppose it and to give our reasons for doing so, which are rooted in South Africa's Constitution. It is our submission that none of the IEC's reasons for seeking a postponement of the election pass muster and hold water. And in fact, we answer every single one of the reasons the IEC gives, showing that they can easily be answered and that there is no reason whatsoever for the IEC to ask the Constitutional Court to help it to violate the South African Constitution, because that is indeed what it is doing. Many people in South Africa seem to think that postponing an election is like postponing any other event or function that one might postpone if it were inconvenient to hold it at a particular time, or even potentially risky to hold it. Holding an election falls into an entirely different category, because an election is the only event the regularity of which is governed by our Constitution, and in fact by the very first clause of our Constitution, in the founding provisions of our Constitution, which require a super majority in Parliament, in fact a 75% majority in Parliament, in order to change. And it is obvious that the ANC, in wanting to postpone the election because it doesn't suit it to have an election now, the ANC, realizing that it could not get 75% majority in Parliament, has sought another way, and in our contention, an unconstitutional way of trying to get the postponement of the election that it wants. And our submission to the Constitutional Court, which will be joined to the IEC's application for a postponement for the election, makes the case, I believe unassailably, that not only can the election logistically and with the right COVID protocols to protect people be held in October when the experts agree there will be a lull between peaks of the infection, but that indeed it would also be unconstitutional to try and postpone the election under the Constitution, because that would require an amendment to the Constitution, or at the very least a suspension of the Constitution, which the Constitutional Court has no right to give. The Constitutional Court indeed has the primary task of defending the Constitution and cannot be placed in a position by anyone to help violate the Constitution. In fact, if the Constitutional Court were to help either suspend or amend the Constitution, it would create a fundamental constitutional crisis, because the Constitutional Court would put itself above the Constitution and set a precedent that in future could lead to a small number of people in the Constitutional Court unilaterally amending the Constitution as and when they see fit, which cannot possibly be right. The Constitution itself prescribes a mechanism for changing the Constitution. That mechanism is the requisite majority in Parliament. 66.6% for most of the clauses, but a supermajority for the founding provisions of the Constitution, which include the regularity of elections. So it is absolutely critical that we place this application and join it to the IEC's application before the Constitutional Court, because any finding to postpone the election in violation of the Constitution or through suspending the Constitution would itself be unconstitutional and create a constitutional crisis, because the Constitutional Court will not have defended the Constitution, but placed itself above the Constitution and facilitated the violation or the suspension of the Constitution. And so I hope everybody understands why this is so critically important. It is not just the postponing of an election to a more convenient time, in the same way that one might, for example, postpone a braai because of a bad weather prediction, or even because most of the guests to the braai might have been ill. It is something that goes to the very, very heart of our democracy and our constitutionalism. And for that reason, we are joining the IEC's application. Now, the key person who has made our submissions to the IEC has been Werner Horn. He is himself an advocate, and he himself understands very clearly, and is there for that reason, the constitutional workings and what is required to change the provisions of the Constitution. He was primarily responsible for drafting our submission to the Constitutional Court that will be joined to the IEC's application. And I would very much like Werner to come in now through Siviwe to explain why it is possible to hold an election on the 27th of October, even in terms of the IEC's own timetable, why it is still perfectly possible to hold a registration period, which is absolutely essential to a free and fair election, because we cannot possibly disenfranchise up to 9 million people if we don't hold a registration period, and why it is perfectly possible, like over 100 countries have done worldwide, to hold elections safely, freely, and fairly during this pandemic, and as South Africa has itself done in numerous by-elections without any reported spike in COVID, and why it is entirely possible to extend those preparations across the country, except the IEC has just neglected to do so and is trying to get itself, and with it, the ANC, off the hook of having to hold elections on their due date. Siviwe, can I hand back to you?
Thank you. Thank you very much, Helen. Werner, if you can perhaps just highlight what are some of our key submissions in our papers this morning, and then we will conclude and take it over to a Q&A.
Thanks, Siviwe, and good morning to everyone. Yes, Helen alluded to the
You're
fact
on mute,
that
Werner.
on my side, I'm unmuted.
You're unmuted, yes.
Yes, thank you. So Helen has referred at length to the fact that we make out a strong case that the regularity of our elections are foundational to our constitutional democracy, and that there's really, in terms of interpreting our constitution, which is the primary duty of the Constitutional Court, not much for the court to do. It's quite clear that by the 1st of November, we must have the local government elections. We, in our submission, however, will also deal with the underlying argument of the IEC that, based on the Moseneke report, it is objectively impossible for the Commission to deliver free and fair elections by the due date of the 1st of November. We, in our submission, will point out to the Constitutional Court that, unfortunately, the Moseneke report, by and large, cherry-picked the portions of scientific data and advice put in front of the Moseneke inquiry, which ultimately suited the argument for a postponement. As Helen has pointed out, it is quite clear that most of the experts that did appear in front of Judge Moseneke clearly admitted that the likelihood is very big that we will be in the slower infection period between a third and a fourth wave by October. And it is also quite clear that the risks that will be associated with a February election is both unpredictable and still very clear. So in that regard, we will make out a case to the Constitutional Court that the whole argument that a free and fair election could rather be ensured in February should not be accepted if the totality of the scientific advice to Judge Moseneke is taken into account. We will also in our submission deal with the whole argument around the fact that a larger amount of vaccinations ultimately could lead to a lower risk of infection. And in that regard, we are strongly of the view that both Professor Karim's advice to the Moseneke inquiry should be taken into careful account. And we will also point out, as Helen has alluded to, that other scientists have already now indicated that the so-called community immunity, which was the big issue around the February election, in all likelihood will not be reached by February, and that some of those scientists have subsequently, in fact, said that it will be important for us as a country to start living to live with the virus and amidst the pandemic. Of course, it is so that the big weakness around free and fair elections in October at this stage centers on the lack of effective voter registration. And everybody now is well aware that the proclamation of the election on the 3rd of August by the Minister of Local Government, Cooperative Governance and Traditional Affairs has effectively closed the voters' roll for in terms of Section 6(1) of the Municipal Electoral Act. We are, however, of the view that the Commission should have considered rather opting to ask for an order that either the proclamation be set aside and be redone on a later date that will facilitate voter registration in the meantime, or ask for an order of the court that the operation of Section 6(1) be suspended until after a voter registration weekend. That ultimately, that suggestion was rejected by the Commission, and we will now in our court papers point out to the court that this is an alternative to postponement. On the Commission's own version of events, it will be in a position, or it will be prepared to have a voter registration weekend by middle of September. We're of the view that the court must even direct them to have the voter registration sooner rather than later. But even with a middle September registration weekend, the Commission has in the past typically indicated that it needs between 25 and 30 days, calendar days, to then end up with a certified voters roll, which would mean that if Section 6(1) of the Municipal Electoral Act is suspended pending voter registration, the Commission could still have a final voters roll by middle of October, which of course would then enable the election to proceed on the current date of 27 of October. So ultimately, we also will make out an argument to the court that the Commission must answer to the statement which we will make that it cannot be that in the midst of the pandemic, when all of us have to adapt, the Commission wants to maintain the same rhythm, the same type of comfort zone in preparing for the elections that it has become used to. It's not fair to South Africans, it's not fair to political parties, and it's ultimately will have the impact of undermining our constitutional democracy to allow for the Commission to say, we've not dealt with voter registration effectively up to now, and on that basis, we now need a postponement of the elections. So ultimately, it is so that would require, as I've alluded to, quite possibly the setting aside of the proclamation, but specifically also a redrafting and a reproclamation of the election timetable. But from where we're looking at it, specifically if one also takes into account the characteristics and the capabilities of the new generation voter management devices, which the Commission will be using for voter registration going forward, it should still be quite possible for the Commission to register everybody who's interested as a voter, or to change their address in order to update their registration status for an election in October. And if the whole saga is looked at in an integrated way, ultimately it must be clear that this will be the best option for us as a country, both from a perspective of safeguarding the integrity of our constitutional democracy, but also from a perspective of arranging the election in a period which, from a wave perspective, will be a period in which we will have more certainty than the uncertainties around a possible fourth wave, which it is now becoming much clearer on the advice of scientists, the likelihood of it arriving as late as January and then again impacting on the preparations for a February election. That likelihood is growing stronger by the day. Thank you, Siviwe. That's all from my side at the moment.
Thank you very much, Werner. I'm going to ask Helen if you can just, because of course there's multiple technical elements to this, if you can then obviously just outline in key point form what our submission to the ConCourt will include, what key arguments are we making in opposition, and what relief we are seeking. Yes.
I think Siviwe was asking me that. Am I right?
Yes.
Okay, good. Okay, thank you very much. Then I will answer that. Number one, I just want to say to all of the journalists listening that we will send you a comprehensive press statement, which will include all of the points that have been made. So if you've been scribbling in shorthand like anything to get down every word we've been saying, don't worry. It will be sent to you in a summarized form, but a comprehensive form. The second thing is Siviwe has asked me to try and briefly summarize the key points, and I do so as follows. Number one, the IEC has made out no case, either based on health grounds or logistical grounds, to justify such a drastic step as the postponement of an election. Secondly, the postponement of an election, unlike the postponement of any other possible event in this country, is actually prevented by the founding provisions of our Constitution. In fact, Clause 1 of our Constitution, 1D, and is protected by a 75% supermajority in Parliament, which means that the Concourt has no power at all to change this in any event, because their job is to defend the Constitution, not to facilitate the bypassing of the Constitution or the suspension of the Constitution, let alone the changing of the Constitution. So the Concourt should not be put in a position where they're asked to do this, because if they were to accede to the IEC's demands, they would be, in fact, fundamentally violating their own role, which should be to defend the Constitution against all comers. And it would create the impossible precedent of a small group of people being able to override the Constitution, should they see fit to do so, and bypass the very mechanisms in the Constitution that have been set out to amend it, which is a supermajority, 75% in the case of the founding provisions, and a 2/3 majority in case of the other provisions in Parliament, where the representatives of the people sit to change the ultimate law according to the prescribed ways of doing so. So firstly, the critical point is that the IEC should never have done this. It doesn't make out a case for doing it, and it's put the IEC into an impossible position. And it was actually underscored by Judge Moseneke himself when he said, well, thank goodness I don't have to decide about the postponement of the election, so I'm going to pass it on to the Constitutional Court, which puts the Constitutional Court in literally an impossible position, and in our view creates something of a constitutional crisis if the Constitutional Court were to accede to that demand. The second point is, as we show point by point and drawing on the expert evidence that appeared before the Moseneke Committee itself, and using the timelines given by the IEC itself, that it is perfectly possible to meet all of the conditions that are required for a free and fair election, including, crucially, voter registration, by the deadline for the 27th of October. It'll obviously be difficult, and the IEC will have to get out of its comfort zone and its normal scheduling, which has been completely behind schedule so far. But even now, with a huge effort, it can still meet the scheduling requirements to hold an election by the 27th of October. And like everybody else has been required to do in the country, the IEC has to leave its comfort zone and do what has to be done, because it has only got one job in the world, and that is to make sure that we can hold regular, free, fair, and safe elections. That is the IEC's job. And it's not as if this pandemic sprang on us yesterday. It has been coming on for almost 18 months now, and there has been all the time in the world for the IEC to prepare to run a free, fair, and safe election, as has happened in other countries all over the world, and as has happened in South Africa. The only constraint on the elections this time around would be mass rallies, which are forbidden in any event, and will most definitely be forbidden by next year if we are, as is broadly predicted, in a fourth wave early next year. So that condition won't change on the proposed postponed date of the election to next year. So we have to learn to adapt to running election campaigns without mass rallies, which is hardly an integral component of selling your position to voters, given all the other mechanisms, especially with technology today, that can be used to spread the message. So we are basically arguing that it would be a fatal mistake to postpone these elections, We are arguing that it is done for the convenience of the ANC that would not like to have elections now, A, because it's not ready, and B, the timing for them is not propitious. And if you ever get to a situation where a ruling party can postpone elections because it's not convenient to hold them, you are into the arena of banana republics, which is precisely why the Constitution has made it so very difficult to change the regularity of elections, and certainly made it very difficult to suspend the Constitution. So that, Siv, is the best summary I can do for you before we take questions, and just again commit to the journalists that they will be getting a full statement. Thank you.
Cool. Thank you very much, Helen. And thank you very much to the people who are joining us on our live streaming platforms. We will now be opening up